Hi, I'm Stefan from Admetrics. We provide solutions for advertisers, agencies, and publishers. Ad verification, brand safety, fraud prevention, viewability, and so on. In this video, I'd like to give a brief introduction to GDPR, the European Privacy Regulation, for organizations that deal with personal data, because of the impact the regulation has on almost every business, whether it's located in the EU or not. As an ad tech company, we're also affected by the regulation, and even though we made sure we're compliant, we see a lot of companies struggling with it, or even not knowing about it. GDPR codifies joint liability, meaning if several companies are involved in collecting and processing personal data, which is how it usually happens for ads, all of the companies involved might be held liable for damages caused by non-compliance by one of the company in the chain. So it's really important to understand what GDPR is and how it impacts your work with your partners. If you're one of our clients and want to know about our compliance with the regulation, how we got there, and what you should do to comply, then please check out this video. GDPR, or General Data Protection Regulation, is a regulation that was approved by the EU Parliament and outlines a set of rules for what kind of data companies are allowed to collect and how they can work with this data. The basic idea is that data of the people who reside in the EU now belongs to them and not to the companies. And it doesn't matter where your company is located, the United States, Australia, Asia, or somewhere else. As soon as you are dealing with EU citizens or residents, you have to comply to the regulation, even if you don't have an office in the EU. The UK has to adopt GDPR too because it's still part of the EU, but they decided to stay with GDPR even after Brexit. So everything I'm going to talk about applies to the UK as well. Companies that do not comply face enormous fines. It's 20 million euros or 4% of the annual worldwide turnover, whichever is bigger. The most interesting thing is that if several companies are involved, for example, one of them is collecting and other one is processing the data, both companies might be fined in case of non-compliance. Of course, not all the companies can survive the fine, and even those who can't ignore it. Here's what's expected from every company in the world when they're dealing with people who reside in the EU, or when they're processing the data within the EU. First of all, companies must get consent to collect and process personal data, and people must be able to withdraw the consent just as easily as they gave it. Second, companies are not allowed to collect more data than they need, and it's against the law to deny services to people who don't want to share the data. It's also illegal to force anyone to provide the data in exchange for a service. For example, I give you something if you subscribe to my marketing emails. Models like this don't work anymore. Next, the regulation is trying to codify an engineering principle called privacy by design. The intention here is that anyone who works with personal data must develop their processes, products, and services, always having data protection in mind. So data privacy shouldn't be something that you put on top when everything's done. Rather, it should be an integral part of everything your company does. Unfortunately, GDPR contains a very broad definition of what it means to follow the privacy by design principle, basically leaving the details to local regulators. Because of the lack of clear guidelines, it is likely that the market will have to wait for the first court decisions to see how regulators and judges understand this principle and whether their definition matches the industry standards. Owners of the data, people who reside in the EU, now have the right to access the data. Anyone can say, I want you to email me all the data you have on me, and the company is obliged to do it within 30 days, or they might be fined. Not only that, but people can ask companies to erase the data or even transfer it. All data breaches must be reported to the authorities in 72 hours, regardless of how big or small they are. Many edtech companies must have data protection officers. These people are relatively independent employees who report to the highest level of management and supervise all the activities with data in the company. Furthermore, companies must be able to demonstrate and prove to the regulators at any given time that they comply with the regulation. On top of that, GDPR is only part of the story and covers only personal data. Soon the EU is expected to issue a new regulation called e-privacy. It's going to additionally cover all communications, for example, things like instant messaging, and it defines when a company must get consent to be allowed to set cookies or track users. In conclusion, the EU is quite serious about data protection. Given the fines, every company must comply with the regulation if they want to survive, but that's not even enough. Companies are still at risk if their partners are not complying, so they'll have to ensure compliance by third parties. If you want to understand how we made our tech stack compliant with GDPR, watch this video. Feel free to subscribe to us and follow us on Twitter and LinkedIn to get the latest updates. Our website is admetrics.io. I'm Stefan. Till next time.